Negotiations, it turns out, is my favourite, and my plan for today is to convince you why it's my favourite, and that it will be your favourite too. So, one thing that you've heard about is negotiations as a competition. We've always talked about it as negotiations, just full stop, that's it. But today what I want to try and show you is that we're actually talking about a specific type of negotiations at this law school, which is interest-based negotiations. So of course, first question is, what the hell is a negotiation? And going to our trusty friend Google, it turns out that negotiation is a discussion aimed at reaching an agreement, which I think is a pretty good starting point. And you can see negotiations, the reason why it's so key and so important is that it appears everywhere, in not just law, but also in your everyday life. You might be having a discussion with your family about going out to a party on the weekend, and that's the time when your negotiation skills really come in handy. So some key examples would be, for example, business deals, diplomatic agreements. Politics is just filled with negotiations, but it also becomes this simple stuff like weekends plans with your family, asking for things from your family, where and /all, where do you want to eat. Those are types of things in which negotiation skills are really key. So my hypothetical example is this one, right? And hopefully, let me know if this is something you've come across before. Has anyone had that chance where you're trying to sort out dinner plans? Person A is like, hey, what do you want for dinner? And person B is like, how about we get some takeout from a place down the street? Hint, hint, You're like, okay, well, nah, let's try a new place in Newtown. I don't want to try Taiwan. I've been there too many times, just had it too much. The other person's like, come on, I really want some takeout, don't want to go out, can't be bothered, it's too far. It's like, come on, this new place, it's great, let's try something new. And it's like, nah, just not really feeling it, sorry. Anyone been through this, trying to sort out dinner plans? Yeah, bit of a mess, yep. Okay, so the question for us is, using that example, how do we use the skills we gained here to kind of get over that? How does it work? How does these negotiations work? And what do we do? And so the key thing that I'm going to teach you in this particular session is this concept of interest-based negotiation, which is not just that sort of back and forth of like, oh, I want to go there, I want to do this, how do I get past that? It's about an actual skill-based skill set that will get you past that sort of hurdle by using what are essentially is called these interests. So, what is an interest-based negotiation? Well, it's interactive problem solving, focusing on interests rather than positions. Okay? Interests rather than positions. And I used to try and accredit this to myself, but when I did some Googling after I wrote this down, it turns out it's actually mediate.com which came up with this. So cite that as your source if you end up using it. But the key thing is, well, okay, what is the difference between a position and an interest? Yeah, they're the key things that we're going to have to establish. Now, position-based negotiations, or positions, is something we're probably all very familiar with. It's what you want or what you need. For example, I want takeout. That's a position, right? I want takeout. Another one is I don't want to agree to that contract. Another one, that's a position, right? And for example, in politics, please don't send troops to my country. Very standard type of position, okay? But the key thing for us is, well, what's an interest? Well, the interest is essentially the why behind a position. Yep, it's the why behind a position. So in interest-based negotiations, we take it one step further. Instead of just saying, I want takeout, you say, I want takeout because I want something easy and convenient. Yeah? There's that extra line, which is the understanding of why that's happening. Secondly, I don't want to agree to that contract because it will ruin me financially. Or finally, please don't send troops to my country because you risk destabilizing the region. All right? That kind of situation. Now for us, if we take those statements, the last part for us is, well, what is the particular interest? Okay. Once you go through that step of asking yourself the question of why something is happening, the interest is literally just the small statement that encompasses that why. So for example, the top one, your interest would be convenience, right? The reason why you want takeout is because it's easy and convenient, so therefore your interest is something convenient. Okay. Something convenient. Any ideas on what this second one, this interest might be? I don't want to agree to that because it will ruin me financially. What might be our interest there? Yeah, financial circumstances, financial security. Yeah, and the third one?
Stability.
Yeah, stability/safety, right? So these sort of like really key statements or key words that encompass the entirety of what your interest is as a person, right? It's not a position, it's the interest. And so, why is this important? Well, we return back to this example. Okay? Now, I can promise you this particular example I've had so many times with my housemates where like just trying to sort out dinner is the most frustrating thing ever. But when you turn to interest-based negotiations, it actually starts to be kind of straightforward. You can realize that if you look at people's interests, what you understand is that there's actually a whole range of options that you wouldn't have considered unless you had turned to interest-based solutions. The reason why is, well, let's take these two examples. We've got person A, right? We've got person B. Well, first question for us are, based on these statements, what are their interests? Any thoughts? What would person A's interest be? Yeah, trying something new, right? And person B, what do we think about person B? Yeah, convenience, right? So trying something new, convenience. That'd be the two interests we've got there. So this is like sort of the first fundamental skill base you need for interest-based negotiations. And why is this important for you in terms of determining these interests? Well, if we go back and remember that interest-based negotiations is problem solving, but together, interactive problem solving, then what you realize is, well, actually, there might be a new solution, which is, why don't you try a new takeout place? Yeah, who knew that there was actually a solution to this problem? Is just match both interests by coming up with a new solution, right? And that's essentially where interest-based negotiations applies. Okay, now obviously, in this particular example, I'm using a very basic everyday life example, but if you think about it in terms of lawyers in a contractual setting, where you're representing a client over a contract worth, let's say, billions of dollars, this type of interest-based negotiation is crucial to coming up with an outcome. Yeah, absolutely crucial. But you can see that it applies to almost every scenario in life. And it's really the way to come up with a solution that works for both parties and come up with a solution that everyone's happy with. So again, remember, what is an interest-based negotiation? It's interactive problem solving, focusing on interest rather than positions. So just to start off with, is there any questions on that to begin with? Like, what is an interest versus a position? Is everyone happy with that? Yeah, that's the most like, oh yeah, do you have a question?
Just wondering, so does solution always lead to like a combination of both parties' interests?
Yeah, so we'll get to that in a second. That's a great question. So, in other words, should all solutions match both parties' interests? If you're a good negotiator, the solution will always match your client's interests. That's like fundamental, yeah? If you haven't got a solution that matches your client's interests, like, you messed up, I'm sorry. That's just a big no. But, does it match your opponent's solutions or interests? Well, maybe not. It kind of depends on how you're negotiating, yeah? So key fundamental principle should be it matches your client's interests. Whether it matches your opponent's interests, we might go through a bit of strategy about how you make that work, but it doesn't always have to match your opponent's interests. That's sort of a secondary concern, okay? So first of all, what does the negotiation look like in practice? Now the reason why I have this slide up is because the most common question that I got when I've been doing this presentation is like, where do people sit? Is like quite common. So this hopefully will give you an example of like what it looks like. Generally in a room you'll have two tables next to each other like this. You won't necessarily have two judges, but judges will sit a little bit separately from you. Yeah, you might have two, you might have one. And the two teams will sit across from each other in pairs. Yeah, so this is a paired negotiation, all right? Now obviously, you might not have a whiteboard, doesn't really matter. It just matters that you sit in this format, yeah? And the judge essentially acts as a fly on the wall in the sense that they don't participate, they don't speak, they'll just sit there and watch you negotiate. So you're negotiating against a real life team, yeah? Another team that's trying to represent their client's interests, you don't know what they are. The second thing is, what happens before you actually hit the negotiation is that each side gets given general facts, in other words, facts that both sides are aware of, and you're also given confidential facts, which are facts that only your team is aware of about your particular client. Yeah? Okay, so you don't know what the other side gets, you know what you get. Everyone knows the general facts. Okay? Then from there, you start to hit the actual negotiation itself. It's a 50-minute negotiation, 50 minutes in total. During that 50 minutes, each side gets to call a 5-minute break if they want. They only get one of them. It's optional. You don't have to call it. Yeah? And finally, after you finish that, you have 10 minutes with the judge to self-reflect. Now, let's reflect on how your negotiation is going. We'll also talk a little bit about strategy in that one as well. Okay? So, how does an interest-based negotiation work? Well, it basically goes through these 6 sort of steps. And the reason why I've laid them out is because generally every negotiation moves in this kind of manner if both teams are generally well prepared. So opening statements is number one. Second comes interests, when you clearly define an interest. I'll go through these in a little bit more detail in a second, don't worry. Third is option generation. Fourth is option evaluation. And 5 is a tentative conclusion. Now, when you go into a negotiation, you don't need to spell out these 6 steps in detail. So you don't need to be like, let's go through option generation, then option evaluation. You don't need to do that. It's just to frame it out. You can, for example, state, okay, let's explore interests. 1, 2, let's talk about options, and then 3, tentative conclusion. So that's a sort of easy way to frame it. But again, we'll go through that in a little bit more detail, so it becomes a bit clearer. Of course, one thing that's really important, and on my screen this is in like bold red, but on here it's just black. So the reason why it's red is because it's important, is planning. I promise you, negotiations behind client interviewing will be the least amount of preparation you do for competition, which is great, because in my opinion, like, that's fantastic. The least amount of preparation that you can do, but for like to do have fun in a competition room, that's my kind of competition. Nevertheless, planning is super important. Now, at the beginning, it might take you some time to get used to like how to plan, because, for example, if you're dealing with a negotiation question, you've never worked with a partner before, it might take you a little bit longer to do that first negotiation, to like really think about how the negotiation will go, what you might want to prepare, what you ask, what you do. But as you get down the track, you get more experienced. For example, a negotiation question, usually if I'm working with someone that I've worked with a lot before, will take me maximum an hour to prepare. Be like 1 hour, have it all set, ready to go, and then the rest of it is literally like if I want to do extra stuff to make it easier in the negotiation. Usually an hour at most to do one negotiation, right? So the idea is that as you go through this, you'll get the handle of sort of doing it a lot faster, more efficiently to make that work. So let's go through each one so you understand what exactly this negotiation will look like, right? And hopefully this will give you a really good opportunity to understand what it looks like. And if you've got questions, ask me, like as we go through this, so that we can work through it together. So, opening statements. Well, what actually happens here? So, first part, which is complete pleasantries. This is particularly important because, like, we're all humans. So it'd be kind of weird to just like jump straight to negotiation and be like, all right, I want this term in the contract, right? Just remember, everyone's humans here, and imagine that you're in real life, right? You're sitting down at a table for the first time with people that you've never met before, but you know that you're in here for the same purpose, which is to come up with an agreement. Okay? So, complete pleasantries, what does that mean? Well, you're sitting on either side of the table, the judge will, wait for you guys to start. Probably the most important thing when you meet someone for the first time, stand up, shake their hand, tell them your name, introduce yourselves. That's a pretty key, like, just everyday life tip, It's worthwhile to just like introduce yourself before you start discussing sort of big issues. So do that first, right? Say, hello, my name's Jeremy, I'm here representing blah, thanks so much for coming, etc., right? Just a bit of pleasantries, sort of ease the discussion. Now here are the 3 fundamental things you need to have sort of at the outset. So after you've done those introductions, you sit down, you're ready to negotiate. It doesn't really matter which side starts first, it can be kind of pretty fluid. Usually if the facts have a situation where someone invited the other person, so let's say client A invited client B to negotiate, then client A will start the proceedings. They'll start the negotiation because they're the one who invited it. So there are 3 things though that you need to make sure you hit. 1, good faith. In other words, we're here to negotiate in good faith for the best interests of both parties. That's again pretty nice pleasantry, but usually something that's a bit more legal because you're starting to talk about, okay, we're here to negotiate some terms. Second is confidential. Now this is kind of optional, but generally it's pretty helpful. We're going to keep these discussions confidential between us. Hopefully that's okay. Let us know if there's any issues with you. And usually the other side, it's also in their interest to keep it confidential because, like, things get out and you start to talk about things that are a bit awkward. It could be pretty problematic for both sides. The third one, which is really key, authority. You really want to touch this in your sort of legal careers until you actually start negotiating or representing clients. What authority is you have to remember that as lawyers, you are being instructed by an actual person, a client, which means that you act on their behalf, which means they tell you what to do, okay? Now what authority is, it's the actual legal authority that a client is giving you to act on their behalf, right? So now most negotiation questions will have the instruction which says, your client gives you full authority to act in their best interests, okay? Full authority means you can do whatever you want in that negotiation room, right? Pretty rare that would actually happen in real life, but for the purposes of this negotiation, that's what you get. Yeah, you're making decisions right there and then. Okay, so important to tell the other side that's the case. Yeah, we have full authority to act on our client's behalf. Full stop. Done. Okay, that's all you need. Okay? And then both sides know, okay, yes, we're here to negotiate an actual agreement. There's no need for us to go back to clients and discuss whether a solution works. Okay, cool. Second thing is, give a summary of facts of the dispute from your client's perspective, frame so it's beneficial. So what I've got in brackets there is like what you would do at a high-end level of negotiations. Yeah. In the beginning, the key thing there is just to make sure that you are on the same page in relation to the facts of the dispute. Yeah. So let's say there's a negotiation between the university and a music festival, where the music festival is loud, bass music has been disturbing a lot of classes, right? So the university is trying to work out a solution to that. So summary of the facts would be, look, your client has created this music festival without us knowing. There's really no ability for us to respond to that. What that's doing is really disturbing all of the learning experience that our students could have in our formidable learning environment. We've been here for hundreds of years, and now suddenly out of nowhere, we've got this music festival that we weren't even aware about, which is disturbing all of our classes. We really think it's a problem. We don't want to have to take this to court, but if we can come up with a solution here, we can come up with something that will work for both of us, right? That's a great way to frame it so it's beneficial. It looks like that you're the good side, right? You're doing the good things, and this random music festival just showed up and just kind of screwed everything over, right? So that's the sort of framing the dispute to make it work, to make it more accessible, and also to make it easier for you. Third thing which is important here is as you go through this sort of factual statement, it's worthwhile clarifying anything that might be in dispute. So, suppose that this music festival were to say, well, no, actually we told you that this music festival is happening on blah date. And you'd be like, oh, we don't know about that. Can you clarify what this communication was? You might realize, for example, that that communication never reached the university, something like that. Okay? So that's opening statements. It's sort of pretty standard. It's complete pleasantries and talk about facts. It's kind of the key things. Now, just before I leave that actually, I've left it out, unfortunately, but one thing you should do at this point, which is also just fundamentally crucial, is set the agenda for the meeting. Yeah, set an agenda, okay? Now, what is that? That's literally just a piece of paper which tells both sides what the actual negotiation will look like, okay? So usually on my agendas, I keep them pretty, empty. The reason why is because the negotiation will change as you go through, but I'll always have at the top, it's kind of like introduction, just this stuff, yeah? Second, I'll have exploration of interests. Again, you don't have to copy this, but feel free to work whatever works for you. Third, I'll talk about is option generation, and fourth, tentative conclusion. Yeah, so that way, pretty standard framework, makes it a bit easier to work through, and also means you can use that agenda to really push the discussion if necessary. Okay. All right. Second, what are interests? So here, when you're talking about interests, like exploration of interests or interests in general, just make it really straightforward. It really doesn't need to be complicated here. You can literally just say, our client has 3 interests. Our interests are 1, insert the word. 2nd, insert 2nd word. 3rd, insert 3rd word. Yeah? Full stop. That's it. That's all you really need to say. And then you can elaborate. Now, the reason why I say this is because every judge who is sitting there and watching you negotiate will be writing down exactly what your interests are. The reason why is because that's how we assess how your negotiation went. Yeah? So we want to make sure, 1, have you identified the right interests? 2, are you negotiating according to those interests? Okay? The second thing, though, is that the other side should be doing a similar thing, right? So they should be saying, our interests are, insert 3 words, 2 words, whatever it is, okay? And it's important that you understand what their interests are too, okay, so that you can work with them as well. Then finally, ask questions. Again, pretty standard. It's just trying to make sure you understand exactly what their interests are. The real goal, and this is a tip for if you go through negotiations of sort of high-level teams, the real goal you should have is that you should have a piece of paper in front of you which has your interests on it. It should be 3 or 4, whatever you've written down and prepared earlier. And next to it, you should have the other side's interests in words, right? Really key, they have 3 interests, there are 1, 2, 3. Yeah? And here's a little tip as well. This is called anchoring your interests, or anchoring the negotiation. Literally spin the piece of paper around, show it to them, and say, are your interests 1, 2, 3? Yeah? So you want a yes or no answer. If they say yes, you've anchored the negotiation. Okay? And I'll explain why that's important when we get to options. All right, everyone understand that little technique? That's helpful. So, option generation. Now, this is where things or negotiations can sometimes get really messy. Okay? So essentially how this area works is you want to try and generate as many options together, right, so that you could start to pull them together at the end to form a solution that works for everyone. Now, the key things here is that often, this says here, generate options without commenting on or evaluating them. Often what you'll find is that teams will try and jump on an option early without realizing that by doing that, you're actually hamstring yourself on future issues. Yeah? So let's say you had a negotiation. Let's take our music festival example. The issues in the negotiation is 1, the sound, obviously a big issue. 2, let's say they broke a window, so there's sort of like economic loss. And 3, this communication issue, somehow it's like the university's fault for not getting the communication, right? 3 issues. Well, suppose that you agreed on option 1, that they'll limit the sound to only certain hours of the day, right? And the university, you're representing the university, you think that's a great idea. But then you hit issue 2, which is the economic loss, the window frame, and you realize that they're not going to budge. Now the problem is that because you've locked down that first issue, you have no room to move there. Yeah? If you try to renegotiate that, then the following question I'll ask you is, well, we just agreed to it. Why are we changing that option? Yeah? So hence, try to do your best to just propose stuff, not necessarily agree to them. If the other side is trying to agree to them or trying to pick something, just be like, okay, that's great. For the moment, let's just write it down, keep that in the back of our minds that you prefer that option, and we'll come to it in when we start to evaluate things. Yeah? It's an easy way to say, yeah, okay, cool, I note that, but let's sort of move on. Okay, and the key thing here as well is if you can find options that work for both parties, propose options for mutually beneficial gain, then that's really good too. That is obviously a solution that works for everyone. All right, evaluation, this is again pretty standard. This is literally just evaluate each option and come up with a package that works for everyone. If you have a negotiation which has moved quite structurally, which to be honest, I'll admit, in the first year of negotiation when I did this, never happened, it's always a mess, right? But you eventually get the hang of it. Then you could evaluate each option and start packaging them together, and this is where the negotiation really hits its sort of like tail end. Time might be running out, you might have only 10 minutes left to come up with a solution, or 5 minutes left, yeah? And you're looking at a page of all of these options and being like, fuck, how do I make this into something that will work for our client? So this is where it really hits sort of, you need to put the gears on, yeah? But essentially the goal here is that you want to come up with a solution that meets your client's interests the best. Yeah, that's always the primary solution. Second, how do you get the other side to agree to a solution that will meet your client's interests the best? Well, you basically try and work on the fact that you've anchored their interests and you make solutions fit their interests too. Yeah? So you're actually playing both sides almost, right? So you want to essentially try and make sure, or if a side is not really budging on a particular issue, let's say there's an option, it looks like that it fits their interests really well, but they're not willing to agree to it, then you need to ask yourself, okay, 1, do I need to sell it more? Do I need to try and make it fit their interests further? Or 2, are they hiding something? Yeah? Because if a side is not agreeing to a solution which clearly fits their interests, ask the question and be like, this looks like it fits the interest you said yes to earlier, yeah? You said your interest was convenience, why don't you want this takeout option? I don't understand, yeah? So that way, they might be like, oh, it's, got something else going on, yeah? And that reveals something else to you. Okay, so that's sort of like a helpful tip as you go through. Finally, the last part is tentative conclusion. So in other words, you would have hopefully reached some idea of what kind of options will work. The best case scenario is that you actually come up with an agreement. Yeah, you have terms of agreement on a piece of paper. You've signed it, you're like, yep, we're happy with this, we're going to head with, yeah. Other solutions that you might come up with, well, you might not reach that level. So another level might be, for example, okay, look, we've agreed that, term 1, 2, and 3, we're happy to agree to those. We're not so sure about this last issue, which we still have left to resolve. So let's meet again in 1 week, work out that last issue. Yeah, and that's how you would conclude, given time constraints there. All right. Note that at 50 minutes, the judge will just stop you, or they'll just put down their pen. They'll be like, all right, negotiations is over. Yep. So if you're not done by 50 minutes, that's it. Too bad. Yep. It's finished. Cool. Okay. Finally, what's self-reflection? Self-reflection is probably the most key bit. The reason why is because judges will never see what your preparation looks like. This is the time to show them what the preparation is. Yeah. Now, generally in self-reflection, judges will take it in different ways. Some of them will just sit there silently, really awkwardly, and let you just awkwardly talk. Other judges will just ask you pointed questions and be be like, what did you do in this scenario? Or how did you prepare this, right? Just work with whatever you got, because you kind of have to be flexible as you do it. But the key things you want to hit on here is stuff related to, for example, your teamwork, your preparation, your strategy. All right? Judges also want to see you note what you did well and what you didn't do as well. You don't really need to try and like sell it to a judge, right? That's not really the goal in the self-reflection. The self-reflection they want to see is that you really understood what worked and what didn't work in that negotiation. Yeah? That's kind of the key sort of fundamental bits. So you have 10 minutes to prepare for that and then 10 minutes to walk back in. So that gives you some time to work with your partner to be like, what worked, what didn't work, that kind of thing. Okay? All right? And then, yeah, judge might ask you different questions, but these are the kind of examples that you'll get. So what went well in the negotiation? What would you do differently? What strategy did you adopt and did it change as you went through? Yeah, how did you adapt? All right, cool. Oh, what were the key developments of the negotiation as well? So stuff just in relation to like, what does negotiations look like? How did it operate? Okay, were you satisfied with what you achieved? Okay. Were there any issues? All right, cool. So, judging criteria. This is a key bit. You can find this in pretty much every comms handbook, so I won't go through this in too much detail. But there are 9 sort of criteria that follow through. They talk about all the different aspects of the type of negotiation you're dealing with. They're also weighted differently, so make sure to have a look at sort of like how they're weighted to get an idea of sort of what you would need to focus on, what things are weighted more. The one that people always ask about is ethics. Yeah, what is negotiation ethics? Negotiation ethics, and you'll come across this in any negotiation competition you come to, is essentially don't lie. Yeah, don't lie. That's all it can be summarized to. The reason why is because a lot of these negotiations are not one-off situations. In other words, it's an ongoing relationship between two parties. So if one person were to lie in negotiation 1, that causes huge issues for the rest of the negotiations. Yeah, but obviously because in this competition, you just meet each other once. Yeah, you might not see that ramification. So essentially it comes up in our judging criteria, which is ethics. Now, how does the judging criteria work for ethics? Basically, if you lie, you get a 0. Like, that's it. It's just 1 or 0. Like, there's not really any option here. Yeah? So be really clear that, like, lying is just not permittable in these types of negotiations. A judge will slam you for it. They'll just straight away, like, give you a 0 for that. Okay, final tips. So, hopefully you've got an idea of how negotiation works, right? You get a little bit of idea of what strategy looks like, okay? Now, this particular section, it's kind of hard to explain like how to do a negotiation well until you actually do it, because you kind of learn by doing, trial by fire, that kind of thing. So you get an idea of hopefully what all these points mean as you get a chance to like crack it out. But hopefully I can give you a few things that are really key to help make your life a little bit easier. So you're not like me now in my first negotiation where like both sides like stood up screaming at each other, like pointing fingers. That actually happened, by the way. It was literally like pointing fingers, being like, you fucked up, blah, blah, blah. Yeah, don't do that, okay? So key, what not to do, don't be hostile or aggressive, yes? All right? So that's the first key scenario. Second thing is what to do. Focus on your interests rather than positions. I cannot stress this enough. This is the most important thing that we see in interest-based negotiations. You need to be able to pin down your interests and pin down the other side's interests, okay? Second is separate the people from the problem. So to avoid getting into this scenario where both sides like standing up, screaming at each other, yeah, just separate out all the personal issues and just focus on, okay, look, I understand that you're aggrieved, that you're having some hostility here, but what we're here today is focused on getting a good outcome for our clients, right? We're here to come together. The reason why we sat down at this table is so that we can reach a solution that really works for both of us in the long run, and we don't have to see each other necessarily ever again, yeah? So separate that, hopefully it makes it easy to work as sort of a final goal. Work as a balanced team, that's really important. Teamwork is one of the criteria. So make sure that you're both equally contributing to the negotiation, all right? Even if it's separate in the preparation, the actual negotiation, the judge will determine it basically on how much you speak. And what not to do, don't lie, that's a big one. And finally, don't interrupt the other side when they're talking. A very common scenario that we see in negotiations is like one side just really wants to like dominate the negotiation. So they'll just like keep talking. And I've like been in the final where that's like happened. Usually that's actually like a 0. That's not a good negotiator because they're not actually negotiating, they're kind of just lecturing, right? And no one wants a lecture, it's just terrible. So, those are sort of some final tips, yeah? All right, so we've got a few more minutes. Are there any other questions anyone has? Yeah.
What do you think about this kind of thing
Yeah. Yeah, great question. So what to do about whether or not, like, should you make the first offer in negotiation? So key thing is that in position-based negotiations, that's true. And the reason why is because in a position-based negotiation, it's usually like, I want $1 million. The other side's like, we want to pay you only 500,000. So you're like, okay, let's meet in the middle at 750,000. Yeah. In interest-based negotiations, that actually never comes up. And the reason why is because what you're talking about instead there, not necessarily about like money figures, you're actually talking about the interest behind it. So it's like, okay, I want $1 million. And you're like, well, why do you want $1 million? And they're like, because it'd be nice, you know? And you're like, well, that doesn't seem like a reasonable outcome, so no, I'm not going to give you $1 million. Yeah? And you're actually, instead of negotiating around positions, you're negotiating around like the interest itself. So they might be like, okay, we actually need $1 million because we might have to pay X amount of dollars to this person in a lawsuit. You're like, okay, well, look, we'd be happy to cover this amount of that lawsuit, yeah, but that only happens if the lawsuit actually eventuates, yeah. So that's sort of a bit of a different scenario. So actually giving the first option is not really a problem, yeah, shouldn't be an issue. Any other questions? Yeah.
So when you're planning, so obviously you look at your own interest
Yep.
and you start with your own solution.
Yep.
Do you start to plan out what the opposite would come up with?
Yeah.
And the ways that you could budge for those?
Yeah, so great question. So the question here is essentially when you prepare, do you just prepare your side or do you prepare both sides? And I try and work out how to do it. My view on this is really good negotiation teams should know how the negotiation will go from beginning all the way to the end, right? So when I prepare for negotiation, I will plan to understand exactly how the whole thing will play out, which necessarily means I have to understand what the other side is going to do. So how I prepare in an hour is I'll have like a piece of paper, yep, I'll draw a line straight down the middle, and the line will essentially be our side, their side, and start off with interests at the top. So like, here are what our interests are, here's what I think their interests will be based on the general information we've got, yeah? And then you start to talk about, okay, here are the options that will work for us, here's what they're going to propose, here is what will work, what won't work. So I'll try and plan it out all the way from 0 to 100, yeah. So, why is that important? Well, the more you prepare about the other side, the more you're not going to be surprised by anything that comes up in negotiation. So as soon as you like, that side is like, our interests are 1, 2, and 3, you're like, cool, okay, we prepared all 3, so like, shouldn't be an issue. If they come up with a 4th, which is a bit unusual, then you might be like, there's something a bit deeper in the facts that we didn't know about. So we might depress a little bit more to get through that. Yeah. Yeah.
So you know the facts that are only given to one specific party,
Yep.
how do they usually play out? So will you bring them up openly or kind of, do you use them almost like as a tactical advantage, or do you have to kind of play with them as though you know what they are but you can't let the other side know what they are?
Yeah, great question. So when you get confidential facts, they're essentially your client instructing you. So like we try and treat it kind of like real life. It's literally what your client is telling you to do or not to do, and facts that may be good or bad for them, kind of defense. So some confidential facts will have a statement in there like, let's say your client is Bobby, and it's like, Bobby accidentally killed a guy. Let's say, that's literally on the facts, right? And it'll be like, Bobby really doesn't want you to tell the other side that he killed a guy. Yeah, okay? And so if that says that, you're like, this is a bit of a problem. Let's not tell the other side that, okay? So, if you get something like that, it's very clearly, if it's not in your favor, don't tell the other side, right? You really should only be telling the other side facts if it's helpful, yeah? Helpful for you somehow. Now, there's a problem. The other side might have an inkling that something is wrong, right? Let's say the other side is like, we heard on the grapevine that Bobby might have done something really bad. So they might start to ask you some questions, being like, are you aware of Bobby doing anything that's against the law? And you're like, oh fuck, yes, we are. And the problem again, remember, is that you're under this ethics obligation. So you might have to say something, yeah, you can't lie. So your answer either has to be kind of like circumventing the issue. So you're like, look, Bobby's done some bad things in his life, but that's really not the issue that we're here today. Doesn't everyone do bad things in their life, you know? Right, that's not lying, right? But you're trying to get around the problem. It's just not relevant, yeah? So it kind of depends on your facts. You have to make the call as a team about what you think will be beneficial for the negotiation and what wouldn't be, yeah? Kind of the key is, yeah.
In that circumstance you just mentioned, can we say like we don't know about it?
No, that would be lying, yeah. So if you said, I don't know whether Bobby killed someone or not, right, that's definitely lying because it's clear on your facts that he did, yeah. Yeah.
So the judges have both sets of comments.
Correct. So the judges have everything. They're kind of like bird's eye, like God view, seeing everything, how everything goes on. They're just like watching you do it. Yeah? So So if you lie, a judge will know about it because they literally have it on their back saying, Bobby killed the person. Yeah? Okay? Yes.
Do you have some tips about like how do we find out like if the opposing team actually are hiding something?
Great. Yeah, that's actually a real question. So how do you know whether an opposing team is hiding something? So usually at the beginning when you're talking about the factual scenario, that's a good point to ask about. And the way you do it, in my view, is this strategy where you start, it's like the funnel effect. So you start wide and you just narrow in a little bit, yeah? So in other words, you can start wide and be like, you know, our client is quite concerned by the fact that your client may have committed an offence under criminal law. That's a big issue with this negotiation. Has your client committed an offence under criminal law? And they might give you an answer which is a bit roundabout, airy-fairy, and you're like, well, no, that didn't really answer the question. It's like, has your client committed an offence under criminal law? Yes or no? Like, that's just a yes or no question. If they say yes, then you're like, cool, okay, let's go on a little bit further. What has he committed? Like, what offence do you think he might have committed? Yeah, dig in, dig in, dig in. If they say no, you can just leave it, yeah? But the general technique for the funnel effect is you want to start wide with like general probing questions. So like, is there anything else we should be aware of? You know, is there anything that might affect this negotiation? Yeah, is your client worried about any scenarios of his competitors, like his competitors coming after him, whatever, stuff like that. And then narrow down until you get a yes or no answer. Yeah, that should be like the end goal of these types of questions. Why? Because if they say, let's say no, yeah, and the answer should have been yes on their facts, then the judge is going to slam them for lying, yeah. Otherwise, you know that they're essentially telling you the truth, yeah. So funnel in, narrow down, hopefully give you a better idea of what to do, yeah. The second case in which you will know where someone is lying is when they're not taking an option that they should have taken, or they're taking an option that they probably shouldn't be taking, yeah. It's like both there. So if you've got their interest fixed and you see that that side is like picking something that is a bit left of field, then be like, oh, you know, just noting that your interest is convenience, but you're also happy to drive to Wollongong, this restaurant. So is there something else we should know about? Like, is there something in Wollongong that perhaps is relevant? Yeah. And so that will open up sort of a bit of like, oh, okay, this is a bit of an issue. Yeah. All right, does that make sense? Yes.
How much can you like stray from the facts? As in like in the example of the university and the festival.
Yep.
And like to say you're representing like the festival.
Yep.
And in like you just come up with, and so the university's like, oh, we're complaining about the noise.
Yeah.
Can you be like, oh well, there are other things at the uni to make noise, like SULS presentations that make a lot of noise.
Yeah.
Even though that's not in the facts.
Yeah.
Can you like world build?
Yeah, if you want to, you could do that. Yeah. Obviously, there's an extent to how far you can go. So you can't be like, oh, we've been told that there's like this noise coming from the SULS presentation because the person did negotiate is super loud, like that kind of thing, right? But you could be like, well, you know, you'd imagine on this campus there would be a lot of other noise coming around, right? And so that allows you to sort of like push the boundaries of what's on there. Yeah. Just the other questions.
In the case if you present like an option and the other people agree, they shouldn't have agreed to it, so you have to inkling that they're hiding something.
Yep.
Can you then like research what positions they actually don't really want to take this option in this particular case?
Yeah, so I've actually had that before in negotiation. You have to be very tactful about it. So when the other side picks an option that you're like, oh, that doesn't seem right, yeah, usually you'll follow with, well, hopefully your teammate recognizes it too, so they don't like jump on like, great, fantastic. But you're like, okay, great, I'll note that you have a preference for that option. But it does seem odd, you know, to ensure that we get a mutually beneficial solution, that, you know, you've accepted that option when it's against your interest, and, you know, and you can show them the piece of paper being like, you know, this interest here doesn't seem to work. Is there anything else we should be aware of? And they'll be like, like either they screwed up by accepting an option they shouldn't have, or they are hiding something. Yeah. So you can dig in a little bit more and be like, you know, I don't quite understand why this fits your interest, or you know, is there something else we should be aware of because that seems a bit unusual. Yeah. That hopefully will open up your pathways.
But if they say no to that, like for example, you go, is there anything else that we should be made aware of? And they say no, is that typically lying?
It depends on their confidential facts.
Okay.
Yeah. So some of their confidential facts might have some significance out there, and if it's like, is it relevant to like this issue, then they might be lying. That's sort of a judgment call. But usually if they give you a yes or no answer, you can usually take sort of at its face. If you need to push it a little bit further, then just be a bit more specific about your questions. So like, you know, has your client done this? Is there something related to this? Yeah.
Say you're the one that's being like shady, and they're like, is there anything else we should know?
Yeah.
And you're like, there's nothing else you should know. Is that still right? Could the judge get you for ethics on that?
The judge wouldn't get you an ethics for that, I don't think, but the other team would probably press you and be like, well, yes, it's relevant to the X, Y, Z, right? I would press you really hard. It'd be like, look, there's something we need to know. And look, to be honest, at some point you might have to reveal it, right? You might have to be like, look, Bobby's done something bad. It's going to happen, right? You might have to reveal it, and that's okay. That's not the end of the world. If you have to reveal it, it comes down to the question of how you use that to your advantage. So, let's say the dispute is around, I don't know, Bobby was annoying to his neighbor or something, right? It's a neighbor dispute. You can be like, look, Bobby's done something bad. He's really, really sorry for it, like incredibly sorry for it. He wants to make up for it in this negotiation by giving your client, something that would work, something that really works for both of us. He doesn't want to let this past history influence what's happening here, so therefore, we want to focus on what's happening right now. And that way you can sort of reveal it, but also not let it detriment the entire negotiation. Any other questions? All right, okay, so I'll be around for a little bit after